of We Texans.
Good afternoon, Mr. Chairman, Committee. My name is Debra Medina. I'm the Executive Director of We Texans. I think it's important at the outset to acknowledge the crucial role that the energy industry plays in our state, in her heritage, and in her economy. I know often the comments by landowners are mischaracterized as being in opposition to our energy industry, and I don't believe that that's the case. The contribution that the industry makes enriches the lives of every Texan. I'm cognizant of the need for an unencumbered and vibrant pipeline industry, and I appreciate the work that they do. In order that we all share an equal opportunity to enjoy freedom and prosperity that this state has to offer, we must guard against, however, the temptation to modify law to favor influential entities, and we must ensure that a fair and just law is applied to all. You know, when Justice Willett's opinion was rendered in August of 2011, it may have come as a shock to the industry and to the legislature, but I don't believe it came as a shock to landowners who had been being victimized by the Club of Eminent Domain, as Mrs. Crawford referenced, for years. We couldn't be more grateful to Texas Riceland Partners and Mike Lotta for pursuing the case. I had an opportunity to sit down with, over an extended cup of coffee with Mr. David Holland, who is the possessory partner in Texas Riceland Partners this past week. I'm sorry that Vice Chair Kleinschmidt has stepped out, but I did want to point out something I think he questioned earlier in that case.
Let me say for the record, Deborah, he handed me a note, and he had an emergency meeting at 1:30 on the post-fires that were issues regarding all the fires that were in his district and with his county and city officials, and he had to leave.
We'll certainly want to get this information to his office so that he's aware. You referenced the dicta that are in the cases. I pulled out my copy of Denbury Green, dicta number 7, footnote number 7. Mr. Holland pointed out to me that a writ of possession has never been issued in his case. Footnote number 7 says Denbury Green filed a separate suit in county court to condemn a pipeline easement. You're aware that the case that went before the Supreme Court was a survey case. They filed a separate suit in county court to condemn a pipeline easement. The parties state in their briefing that the county court suit was stayed pending the outcome of the case before us. No writ of possession has ever been issued. That pipeline has been in the ground and operating for 3 years. By what right do they have to be on this man's property? The company has gone from being a $4 billion concern to an $8 billion concern. This isn't a question of whether or not it's a good company, whether or not it's providing a valuable service. The question before us is it a common carrier under our law? As I began to receive calls from Texas landowners facing condemnation actions along the path of the Keystone XL, I undertook an exhaustive review of the statutes and administrative practices that purportedly serve to define and regulate that process. I often hear, oh, but of course they're a common carrier, or oh, but of course they can condemn property. Well, there is no oh, but of course. There must be an objective measure of whether there is compliance. The opening statement in Judge Willett's opinion bears
Deborah,
repeating.
Forgive me for a moment. I neglected to recognize Representative Simpson, who's in the room. You're welcome to come sit up here and join us, Representative. We'd love to have you. Okay. All right. It's safer back there. So.
The Texas Constitution, Judge Willett's opening statement in his opinion, the Texas Constitution safeguards private property by declaring that eminent domain can only be exercised for public use. But for our purpose today, before we explore eminent domain condemnations and public use, we might review to or for the public for hire. What makes someone a common carrier? Eli Noem, the professor of finance and economics at Columbia University, provides a history. He says in England, early common law placed certain duties on businesses which were considered public callings. Common or public occupations included those of bakers, brewers, cab drivers, ferrymen, innkeepers, and the likes. Common in that context meant open to serving the general public. In 1701, an English court found that if a man takes upon him a public employment, he's bound to serve the public as far as the employment extends, and for refusal to do so an action exists, as against a farrier refusing to shoe a horse or against an innkeeper refusing a guest when he has room, against a carrier refusing to carry goods when he has convenience, his wagon not being full. By 1814, with the coming of the Industrial Revolution and laissez-faire economics, common callings were generally limited to what we would today call infrastructure or transportation and communications. Common carriage was applied to freight and carriage companies, inland and ocean water carriers, and by common law, common carriers had three characteristics. They were required to serve upon reasonable demand any and all who sought their service. They were held to a high standard of care for the property entrusted to them, and they were limited to incidental damages for breach of duty. That concept carried across the Atlantic and became part of the American legal system. It was broadly applied to railroads and later other transportation. I combed through, thank you, the University of North Texas for digitizing much of our early law, and could only find the first mention of common carrier in Texas law dating back to 1860. But it wasn't until 1917 that Texas adopted Senate Bill 68, and it read, an act defining common carrier pipelines engaged or to engage in the transportation of petroleum oil, declaring all corporations, persons, partnerships, or associations of persons now engaged or to hereafter engage in transporting petroleum from place to place in this state to be common carriers. While that bill provided the first four definitions of common carriers, which you find in Section 111.002 of the Natural Resource Code today, eminent domain authority was very limited in 1917 and only gave common carriers the right to lay their line along an existing railroad right-of-way or a public road right-of-way. Then as now, however, the phrase in the state of Texas culminates in definition number 4 with a very clear, in our law today, from an oil field or place of production within this state.